The next panel will have a paper by Rebecca Tushnet, who's a professor at Georgetown University Law Center and writes on copyright, trademark, and advertising, and she's also helped found something called the Organization for Transformative Works, a nonprofit dedicated to supporting and promoting fan works, and she now volunteers on its legal committee. And then Carolyn Corbin is professor of law at University of Miami Law School. She, after clerking for Judge Michael on the Fourth Circuit, litigated as a pro bono fellow at Sullivan Cromwell, and then as an attorney at the ACLU Reproductive Freedom Project. She teaches constitutional law and specializes in the First Amendment.
Great. Well, so if you looked at my paper versus the other papers, you might have had the reaction I did, which was the Sesame Street reaction. One of these things is not like the others. And I will just try and make the case that regulation of non-press entities is also an important part of modern speech regulation. And I do think my topic is grounded in Sullivan, although not in Sullivan's protection for the press as such. The aspect of Sullivan that I want to talk about is its bar on liability for derogatory but non-factual speech. It's not because that kind of speech can't do harm. Everyone who survived an American high school knows that it's the non-factual statements that do the most damage. Instead, the fact-non-fact distinction limits and channels defamation liability in a way that, first, we hope is objective and more protective of speech than a subjective standard, and second, we believe limits liability when fact-finders would be inclined to protect the powerful and respected figures over some more marginal characters, both when the marginal characters are plaintiffs and when they're defendants. At least that's what we hope what the non-fact distinction does. So you can now do as much harm as you like to a person's reputation as long as you do it with non-facts like mockery, slurs, and the like. At least under modern defamation law, the particular mechanism of emotional manipulation is fair game, or at least it's off limits for suppression by the government. So my paper contrasts two private causes of action and two government disclosure mandates. So my first point is that trademark law allows exactly the kind of control over non-factual emotional appeals that modern defamation law supposedly precludes. And then the second contrast is, in compelled speech cases, courts have struck down mandatory smoking warnings in visual form, but approved mandatory abortion disclosures and ultrasound requirements that operate in the exact same emotional register. I would suggest that the contradictions of current doctrine could be ameliorated by less distrust of emotion and more acceptance that when information is being conveyed, emotion is going to follow. Our focus should not be on whether deployment of emotion is manipulative or harmful, because we know it can be, but whether it's part of a discriminatory or factually misleading regulation. So when the government does regulate speech, the regulation is going to have an emotional component because human thought is emotional. Our objections, if any, to emotion-based regulations shouldn't be based on how obvious that is. Instead, we should look at the acceptability of the government's aim, especially when non-government speakers are free to use emotional appeals to press their own cases. I'm going to start with trademark and defamation. My claim is trademark law presently authorizes the kind of private control over emotional meaning that defamation law's limitations to facts purports to preclude. The government, in trademark, provides a remedy as between two private parties when one interferes with the emotional valence of the other's brand. And, by the way, people can be brands too, so it's well settled that people are entitled to trademark protection when they are well known enough. Courts routinely protect the aura of distinction and uniqueness claimed by a trademark owner. So we have the Second Circuit enjoining a copyist of Levi's stitching on confusion grounds because otherwise Levi's sales would be affected adversely by buyers' ultimate realization that the pattern is no longer exclusive. Trademark protection in the absence of consumer confusion at the point of sale is justified, at least in part, as a means of preserving the distinctiveness, the status of consumers of the true good so that you know that they have the real thing, even if nobody ever makes a mistaken purchase. Confusion does this in some cases. Trademark dilution, a separate doctrine, allows trademark owners to control emotional meaning, and that's really what it is, full stop. It's not about mistaken decisions at all. Instead, it protects the appeal of a mark, the it protects against what's called the blurring or tarnishment of the mark, which is interference with its singular meaning, again, even when nobody is confused. So another case from the Second Circuit, the court found that a lawn tractor ad actionably diluted John Deere's mark by featuring an animated deer logo running away in terror from a small yappy dog, right? And that implication of wimpiness was enough to suppress the competitor's speech, which was otherwise comparative advertising and completely protected as such. The thing is, American regulators rarely try and suppress non-factual commercial speech. So right now, adorable spokesbears and body spray using boys surrounded by inexplicably attracted women are safe devices to build consumer interest and loyalty and to create positive affect that itself builds the brand. Within this regime, then, this extension of trademark law creates a systemic bias. If the only time non-falsifiable speech about someone else's trademark can be banned is when it's used to get attention, to build your own image, or amuse consumers, the result is that there are special positional advantages given to currently dominant brands. And it's the discrimination in favor of the already powerful that makes trademark law constitutionally problematic when it tries to regulate emotions rather than mistaken purchasing decisions. I'm happy to talk about this more, but I think that this power can't be justified by trademark-specific concepts of economic harm or property because those concepts just can't be made trademark-specific except by pure fiat. It's easy enough to say Jerry Falwell has a property right in his own image. People have tried to do that, but it doesn't solve the problem of, say, Hustler inflicting emotional distress on him by creating a semi-pornographic cartoon about his first sexual experience. So there's this inconsistency. Inconsistency isn't itself a vice, but there's a particular problem when the inconsistency favors the presently powerful and dominant, which is explicitly what trademark law does. It protects strong brands more than new or weak market entrants, and dilution law in particular only protects famous marks, which is to say household names. So I think this should lead to the invalidation of dilution law and certain extensions of trademark confusion law. I also think that this isn't the only place that this tension shows up, right? So here we have it in the private torts targeting emotional methods of persuasion. My other example comes from compelled speech or speech disclosures mandated by the government. So we could talk a lot about government speech. I find this topic broad and unwieldy, so I'm going to just focus on compelled speech instead of things like "this is your brain on drugs," which of course also attempt to evoke emotional reactions. Can the government mandate that a speaker disclose negative facts in a way that's likely to trigger emotional reactions? The present answer is no and yes. No when the speaker provides cigarettes, yes when the speaker provides abortions. So on tobacco, the D.C. Circuit in a 2-to-1 decision upheld the invalidation of congressionally required graphic warnings on cigarette packages. The main problem the R.J. Reynolds majority had was that the warnings were too emotional. They said the graphic warnings weren't purely factual because they were primarily intended to evoke an emotional response, or at most shock the viewer into retaining the information in the text warning. The FDA's defense of the use of images was research showing that pictures are easier to remember than words, which meant that the message, smoking is bad for you, would be better received. The majority interpreted this as the FDA's desire to shock consumers, but it actually didn't reject the factual claims that memory is aided by emotional cues or that other word alternatives had failed to make the risk message stick. So instead they said, well, these are warnings designed to shame and repulse smokers, and that's ideological and not informational. Under the majority's reasoning, the government is apparently not allowed to mandate a warning that works through an emotional mechanism. So the immediate problem with this conclusion is that purely factual words also work that way. Take something that everybody so far finds unobjectionable, price signals. The research shows that price signals trigger negative emotional reactions that mitigate consumers' desires for advertised products. Price, if you see a price, it makes you feel bad about buying and thus decreases your motivation to buy even though you like the product. And nonetheless, price disclosures have been upheld as acceptable regulations of commercial speech because they're obviously related to rational consumer decision making. Still, the Reynolds majority said graphic warnings are unacceptable because they weren't purely factual and uncontroversial. The majority was confident that price-related disclosures are indisputably accurate and not subject to misinterpretation by consumers. This is a false dichotomy, right? There's actually no necessary contradiction between an accurate statement and a misinterpretation. There's a whole branch of law, advertising law, dedicated to dealing with this. I think it's probably connected here to a false dichotomy between reason and emotion, as if there was never such a thing as misinterpretation if you were thinking rationally. There's just no such thing as a disclosure or any other statement that's not subject to misinterpretation by somebody. People vary too much in their attention, their prior beliefs, and their other cognitive resources. And the research is quite clear on this. Somebody always ends up reading, this claim has not been evaluated by the FDA, as this claim has been evaluated by the FDA. So among other things, in the paper I talk about people who have tried to deal with this, including Professor Corbin. She uses what I think is very persuasive social science evidence to say that the Reynolds majority got it wrong. She points out vivid images seem more personal, so viewers imagine themselves at risk rather than assuming themselves immune. Salient images are more likely to be noticed and comprehended, unlike the current textual warnings, and obviously there is no, comprehension is the first step towards taking an action where you've weighed the risks and benefits. But interestingly, in her article on this, she considers one emotional pathway to be dangerous, which is the idea of associating smoking merely with negative affect. So, as she points out, this is the opposite of what advertisers do when they link their product with something that triggers a positive emotional response. Hot girls beer, right? You're supposed to see them and think of them together, and therefore feel about the beer as you do about the hot girls. And she thinks this is constitutionally problematic when the government does it. But as long as the negative image is truly connected to smoking, she considers this to be a legitimate transfer of affect. So there's some sort of line between legitimate relationship and Clockwork Orange style aversive conditioning. And she thinks, given what the FDA put together, what they did was basically unproblematic, except for this one image of a woman weeping uncontrollably, which is too much of a cognitive shortcut. And I think this reaction illustrates the difficulties of distinguishing shortcuts from merits. And of course, we do have this long tradition in the First Amendment of protecting shortcuts from mind to mind as encapsulating symbols like the American flag. Is it really that odd to think that non-smokers who get a fatal lung disease will be mourned, right, perhaps by uncontrollable weeping, or even that smokers who discover that somebody they love has fatal lung disease will feel guilt? And of course, it's interesting too that the uncontrollable weeping comes from a single flat image, right? So there's something going on that you've translated the picture, and now it's uncontrollable weeping, even though you have this frozen moment. Maybe it's quite controlled weeping. You bring stuff to the image, which is what we always do. The government will often want to make rational but not perfectly correlated associations when it imposes a disclosure requirement. And I also think, unlike advertisers who use sex and pleasure to sell, government mandates aren't actually likely to associate completely unrelated things. But it is important to consider private advertisers' willingness to sell products with positive imagery, because you can't get a full constitutional picture without that. So tobacco companies, like every other kind of commercial seller, routinely and even predominantly use images and non-factual matter to make their products attractive. That's the story of modern trademark law. And even with cigarette advertisers reduced to colors, they actually study very carefully what colors communicate pleasure and relief and health, and they use them. So if imagery can distort rational judgment, Reynolds makes it impossible for the government to correct tobacco advertisers' own distortions with a countervailing emotional appeal at the very point it might be effective, the moment of decision to smoke. Now for the other side. While Reynolds invalidated visual tobacco warnings, courts have mainly upheld a different set of emotional interventions related to abortion. And I'm going to depart from many critics in accepting the idea that emotional government appeals are legitimate. The real concerns, which are shared by the critics of emotional appeals as well, are about factual misleadingness, burdens on one's practical ability to obtain an abortion, and misattribution of the government's message to doctors. So the Eighth Circuit upheld South Dakota's requirement that physicians provide their patients with a written statement informing women that a known medical risk of the abortion procedure is an increased risk of suicide ideation and suicide. And this is required even though the best available evidence is that this is not true. The majority, though, concluded that this statement didn't suggest a causal relationship between abortion and increased risk of suicide, and therefore wasn't false or misleading because of the possibility of causation. Now, by any normal standard, this is clearly misleading. Correlation may not be causation, but reasonable consumers or listeners would undeniably receive the message that having an abortion caused the increased risk. This is the ordinary rule of implicature. It would have been just as true to mandate a disclosure that people who take Advil have an increased risk of headaches. Yes, but that seems like an odd thing to mandate. Courts have upheld various other required statements about the whole separate, unique life that will be destroyed by abortion. They've upheld requirements forcing women to view fetal images and hear fetal heartbeats by way of mandatory ultrasounds. And they've treated these requirements as truthful and non-misleading. Of course, there's no way they'd satisfy the standard applied in Reynolds. The aim here is clearly persuasion, not just information. The state's position is that a woman's future self is sufficiently likely to have a different perspective on the present decision, much like a current smoker and that smoker's future self, that providing her the information now will enhance her overall decision-making. We may disagree about the likelihood these regrets will materialize, but the two situations can't be separated on their logic, only on their facts. And it is important that the state, absent the constraints of Lochner, often has a great deal of freedom to find facts. Given this, I think focusing on the emotionality of the government's emotional appeal can divert us from the more basic question of whether the appeal ought to be allowed. So I want to talk about one common analogy deployed against these disclosures, and I think it shows how our underlying concepts about what decisions are rational affect our conclusions about acceptable emotional appeals. So critics often make the point that graphic images of ordinary surgery aren't considered necessary for informed consent. Rationally, the fact that surgery is bloody and gross shouldn't deter someone who needs it from having it. But imagine a state with a substantial population of Jehovah's Witnesses and Christian Scientists. Would they agree that the only rational necessary choice is surgery? Are we prepared to accept the existence of reasons to reject surgery that acknowledge its potential efficacy but value something else more? To press further, consider in many cases surgery isn't the only option. There may be other possible treatments. There may be a patient nearing the end of her life who doesn't want to choose to extend it given the cost in pain and recovery time. To the extent that graphic images make these considerations more salient, that there are real physical costs to surgery, they could be justified, it seems to me. Like an image of a crying woman concretizes and stands for the costs of tobacco use, or the image of a fetus stands for a human life, surgical images, it seems to me, are directly related to considerations that a patient rationally could take into account. However, I do think the surgery analogy proves a somewhat different point, which is that abortion disclosures discriminate in a way we should deem constitutionally significant between a choice uniquely made by women and other medical choices. And this discrimination is likely to reflect sexist assumptions about women's rational capacities. To the extent that the state is deploying emotional appeals in a biased way, and especially to the extent it's forcing doctors to represent its opinions as its own, arguments against forced disclosures are still available even if there's nothing wrong in the abstract with emotional appeals. So it's, in fact, I'm going to return to my point that there is no regulation of information without emotion. Right? It's now well recognized that nobody can weigh alternatives or judge between them without emotions helping guide their choices. Some decisions don't seem emotionally influenced, often because the cultural definition of emotion excludes things that make certain interactions flow smoothly. But that just means the emotion is invisible and normalized, not that it's absent. And my favorite example of this comes from advertising. So we're regularly influenced by aspects of presentation that have no relationship to decisions if we were making them rationally. This is my favorite study because it's a photo of a smiling, attractive woman in the bottom right-hand corner of a loan offer. It produced an increased response rate for men equivalent to dropping the monthly interest rate by 200 basis points, or about 25% of the total rate. The recipients didn't get any increased exposure to the woman by accepting the offer. Even if they did value her smile at 200 basis points, taking the offer was still irrational. So we are regularly influenced in ways we'd be embarrassed to admit if we even acknowledged that we'd been influenced. And of course, I'm not immune from this. I'm not claiming that. So what do we do with this reality? With respect to mediating private disputes, I think it is desirable for the government to refuse to allow liability when there's non-factual speech that affects the audience's evaluation of a plaintiff. This is the rule of Sullivan, should be the rule in trademark law as well. In that sense, it is possible for the government to be hands-off with respect to certain kinds of privately generated emotion, though emotion will necessarily remain one mechanism by which claims, including factually false claims, do harm. On the other hand, when the government wishes to require disclosures from commercial speakers, disconnection from emotion is impossible. We have tried various ways to figure out what the government can and can't do. Some people have suggested that the proper inquiry is whether the government is just trying to inform people or is trying to change behavior, but the government always has both purposes when it requires disclosure, right? So Zouderer is the classic commercial speech disclosure case. They found a lawyer's failure to disclose that consumers would have to pay court costs, even if they lost their cases, to be deceptive, because that liability for payment would matter to a significant number of consumers. If it would matter, then the disclosure doesn't just inform you, it actually changes a significant number of people's behavior. That's what it means for information to be material to a decision. So if the government does have a legitimate interest in having people become aware of certain information, emotion just has to enter into our calculation of how to deliver that information. We're poor decision makers. We rely on salience over statistics, and for us to get to believe in something, we need concrete human examples triggering emotional reactions. So as a result, my claim is emotional appeal should be fair game for the government as well as for private parties, unless that's tied to factual deception. These appeals often make us uncomfortable because they seem like the government is being paternalist and judgmental. They're putting undue pressure on the citizen. But it is important to remember the government isn't the only entity addressing the citizen. If she's vulnerable to emotional manipulation by the government, she's probably vulnerable to other kinds of emotional manipulation. Other entities are already selecting what messages they want her to hear and pressing them on her. Even accepting that deliberate appeals to emotion create autonomy problems that are different in kind from appeals to non-emotion, whatever that might be, our autonomy is profoundly at risk already, and we might want the government to step in to help restore that. So ultimately, I would allow the government to express the preferences it can constitutionally have and to express them in emotional terms as long as it isn't deceptive. This isn't going to solve all problems, I understand that. We'll shift to fighting over what deceptiveness means. We'll shift to fighting over what discrimination means. But this would, I think, give the government significant freedom to require disclosures, and also it would allow us to stop pretending that emotions can be taken out of these decisions, which I think would be a step forward in and of itself. Thank you.
So first, I want to say that I am delighted and honored to be here, and I want to thank everyone who has made this conference possible. And continuing the commenter trend, there is a great deal that Professor Tushnet and I agree on when it comes to emotion and compelled speech, and I'm going to be focusing on her compelled speech part. So obviously, I'll try and comment on where I disagree. But most fundamentally, I agree that emotion and reason are inextricably linked. Consequently, government-compelled disclosures should not automatically be suspect because they rely on emotion. Thus, the D.C. Court of Appeals was wrong to strike down cigarette warnings on the grounds that they were emotional and therefore manipulative. And we also both agree that the government should not be able to compel emotional speech or any speech that is factually erroneous or misleading. And for this reason alone, the government should not be able to compel disclosures that suggest that abortion causes depression or an increased risk of suicide, as these claims are patently false. And indeed, Tushnet's major thesis with regard to compelled speech and emotion is that emotional disclosures should not be off limits unless they are factually wrong or misleading. That is, from a free speech perspective, the government may compel cigarette manufacturers to reveal the gruesome consequences of smoking, and the government may demand that doctors tell patients the state's moral view on abortion and use emotional images to do so, so long as there are no lies or deception. And this approach has the virtue of being clear, but I think it has some limits as well. And first, I think it defines deception too narrowly and overlooks that just as the state can deliberately deceive and mislead you with facts, it can deliberately deceive and mislead you with emotion as well. Second, if deceptive compelled speech is problematic because it fails to respect the autonomy of the audience, right? If our concern is the autonomy of the captive audience, then the goals of the compelled speech need to be considered as well. And third, I think a complete picture of compelled disclosures also has to consider the autonomy of the person forced to articulate the government's message. So starting with deception, Professor Tushnet rightly condemns emotional disclosures that are untrue or misleading. So forcing doctors to articulate the government's disapproval of abortion without allowing the doctor to clarify that this represents the government's view and not the doctor's would, for example, be misleading. And this is presumably because we would give the statement different weight if it came from our doctor rather than the government. Otherwise, Professor Tushnet argues, from a free speech perspective, and she makes clear that she's only focusing on free speech concerns, not other constitutional issues, mandatory abortion counseling is not problematic. And I would define deception more broadly. So problematic deception encompasses not only compelled speech that is false or misleading, but also compelled speech that is, for want of a better phrase, and if someone has a better phrase, please let me know, emotionally false or misleading. By that I mean compelled disclosures that intentionally exploit certain cognitive shortcuts or heuristics involving affect. So, for example, as Professor Tushnet mentions, one shortcut advertisers regularly use is to make you like something not by virtue of its own merits, but by associating it with something else that you like. So it's the difference between trying to persuade you to buy a toaster by showing you a beautiful picture of a toaster and trying to persuade you to buy a toaster by draping a beautiful woman over the toaster. Right? The latter is intentionally taking advantage of an affect heuristic, a cognitive shortcut. And I think just as it's manipulation to intentionally give people false information so they draw the wrong conclusions, I think it's manipulative to intentionally exploit certain cognitive heuristics that predictably lead to errors. And I think most, if perhaps not all, of the tobacco images fall into the legitimate use of emotion category. That is, any emotional response is due to the merits of the claim rather than the intentional exploitation of an affect heuristic. So after viewing these images, you don't recoil from smoking because it's been associated with something you already view negatively, and you're transferring those negative emotions onto smoking. Rather, you recoil because the images depict the actual consequences of smoking. Again, any negative reaction is not mapped onto smoking from another source, but stem from the smoking itself. Now, I'm not sure that every image satisfies this criterion. Professor Tushnet points to this hesitation on my part to conclude that the distinction is not workable. I'm not sure if she means as a theoretical matter or practical matter or maybe both. And I think it is a fair criticism that it's hard to draw the line, although I don't always think it's easy to draw the line on what counts as misleading. I may even be wrong in suggesting that the image of the crying woman is on the wrong side of the line. But I'm not quite comfortable having no line at all. Professor Tushnet suggests that government mandates are not likely to associate completely unrelated things, like the harms of smoking and maggot-infested meat. That's her image, not mine. But I'm not sure I trust the government that much, especially when thinking about the issue in the context of mandatory abortion counseling. So Professor Tushnet states that she sees little difference between smoking and weeping women and abortion in weeping women, and that's kind of actually my point. If the First Amendment allows the government to create a negative association with smoking by intentionally exploiting affect heuristic, it means it allows the government to create a negative association with abortion by intentionally exploiting an affect heuristic. Right? So if the government may put images of weeping women or maggot-infested meat on cigarette packages, it opens the door to allowing the government to force women who would like to have an abortion to look at images of weeping, regretful women or maggot-infested aborted fetuses. Okay, that one was mine. The bottom line is, just as I think it's intentionally exploiting ambiguity to be misleading is deceptive and manipulative and problematic, I think intentionally exploiting affect heuristics to create a particular emotional reaction is deceptive and manipulative. Both lead the audience to draw conclusions, factual and emotional, that they would not otherwise have drawn, and both undermine the sort of decisional autonomy which is at the heart of free speech jurisprudence. Furthermore, if decisional autonomy is what's at stake, then the goals of the compelled disclosure should matter as well, especially when we're talking about captive audiences. Professor Tushnet disagrees and argues that as long as the government's methods, as long as the methods are not problematic, as long as the compelled disclosures do not lie or mislead, they do not pose this free speech problem. Therefore, as long as the means are acceptable, the government may pursue whatever goals it likes via compelled disclosures. It may seek to deter smoking and abortion equally. Right? There's little constitutional difference between the two, she says. As long as the audience can ultimately decide whether to smoke or have an abortion, their autonomy remains intact. She seems to reject that the captive audience autonomy might also be implicated by government interference with the decision-making process as well as the ultimate decision. And I think her thesis, again, is propelled by the difficulty of line drawing. Now, I share her doubts about the ability to distinguish between compelled disclosures that inform and compelled disclosures meant to persuade. Nevertheless, I think there is a difference, and a difference that matters in terms of decisional autonomy, between the government trying to persuade someone not to smoke because smoking is harmful, and the government trying to persuade someone not to have an abortion because the government believes abortion is murder. So trying to unpack this a little bit, I think it's less intrusive, less an insult to a captive audience's autonomy when the government's goal is one it's likely to agree with. And I think that's more likely to be the case when the argument is based on non-controversial, well-established fact, rather than an argument based on a controversial moral position. And Professor Tushnet argues my distinction between controversial and non-controversial is untenable because in this day and age, everything is contested. But I disagree that everything is up in the air. I think that's too close to claiming that there's no difference between truth and falsity because everyone disputes everything. That smoking is addictive and causes cancer is not, in fact, contested. It's a well-established, scientifically based fact. In contrast, that abortion is the equivalent to murder is contested. One might even argue that it's a moral and religious viewpoint over which the country is deeply divided. The second distinction I make between autonomy enhancing and not autonomy enhancing, again, not absolutely clear cut, I also think is not an impossible line. Right? Given that smoking is addictive and causes cancer, it will enhance your autonomy to avoid it. Granted, there may be a few people who like the thrill of dangerous activities, although note that even the vast majority of smokers wish they have never started. But I don't think that exception sort of defeats the proposition that avoiding addiction is autonomy enhancing, and therefore government attempts to persuade people not to smoke is generally autonomy enhancing. Because remember, the question is, does the government's goal impact the autonomy of the captive audience? The same cannot be said about government attempts to persuade women not to have an abortion. Right? Unlike smokers, the vast majority of women who have opted for an abortion don't regret their decision. Right? Even setting that aside, the availability of abortion has enhanced women's autonomy. Therefore, it cannot be argued that trying to persuade women to change their mind about abortion is generally autonomy enhancing. Thus, in terms of infringing on the audience's autonomy, the goal of the abortion disclosures differ from the goals of the tobacco disclosures in at least two ways. The abortion disclosure's goal is based on the government's viewpoint on a controverted moral issue, as opposed to well-established scientific fact. And the abortion disclosures urge a course of conduct that is not necessarily autonomy enhancing, as contrasted with avoiding addiction. Which brings me to my third part, that the government's goal is based on controversial moral considerations rather than on controversial facts, also raises an issue for compelled speech that Professor Tushnet does not address in her paper, which is the free speech rights of the compelled speakers. Because her focus is on audiences rather than speakers, I'm not actually sure what she would think of what I'm about to say. State-compelled speech implicates the autonomy of the compelled speaker. Right? The right to control your thoughts and speech can be violated as much by being forced to speak as by being silenced. Right? Clearly, compelled speech violates some fundamental free speech notions about the control individual people should have over their expression. And this insult to autonomy and dignity is considered worse if you're forced to articulate a viewpoint you do not share rather than facts, sort of Barnett and Woolley v. Maynard. Indeed, this line between compelled factual disclosures and compelled ideological disclosures is fairly widespread in the commercial speech context. That the free speech jurisprudence makes this sort of distinction raises a couple of questions for Professor Tushnet's thesis with regard to audiences. If free speech jurisprudence considers it anathema to force individuals to articulate ideological message, why isn't it also problematic to force captive audiences to hear it? And if free speech jurisprudence is able to make this kind of distinction for speakers, why is it so difficult to imagine it can make somewhat similar distinctions for audiences? So I'm going to stop there since you've been listening to a lot of people speaking. Thank you.
Okay, so thanks, and I think we are heavily in agreement on many things. But I do think, I agree that the question of how you define deception is absolutely the vital issue. The problem is the difference between you're making the wrong decision and you're making an incorrectly informed decision is very difficult. And this is why Lochner is important here. There's a fundamental question of what facts the state is allowed to find. And why I'm worried about the corrosive effect of some of these claims. So it is of note that although you're right that the opposition comes from moral foundations, the state is not saying abortion is murder. Instead, the state is very clearly using consumer protection rhetoric. It might be wrong about that, right? But it is saying we believe that women will come to understand what they've done and they will feel bad, right? And there are reasons why that is both wrong and should be off limits on 14th Amendment grounds. But the government is using the language of information in a way that is exactly structurally identical to the language of information about cigarettes. Now, it's true abortion doctrine is special. Maybe we shouldn't expect it to behave anything like the rest of First Amendment doctrine, but there are a bunch of disclosures we mandate that wouldn't satisfy these standards, from the SEC to the FTC to the FDA, and I worry about that, especially since most of these things don't have the plausible addiction argument, which does a fair amount of work, although I don't think a completely persuasive amount of work on the cigarette side.
Rebecca, I understand your point that we are all, susceptible to these messages, and no one is above that. But we do have some defenses. I mean, surely we've all seen an ad and said, "Look what they're trying to do there. They're so obviously trying to play this card, and I'm not buying it." And I see that. But I'm wondering if you're open to the idea that there might be audiences who don't have even, have no to little of even that ability. I'm thinking first of children, who might just really not even be able to filter that much. It would have more of an effect. And if there are these vulnerable audiences, going from children, you could go to people who are in, a horrible health situation that just got terrible health news, sort of like your example, having to decide on whether to try surgery, or someone who just, experienced a death. And then if you accepted that, then you could go to a woman facing the decision about an abortion. And my point would be that that would be an audience that has even fewer of these abilities to deal with the emotion versus somebody standing in a drugstore trying to decide whether to buy a pack of cigarettes. I'm just curious if you think that there could be a way to think about the different types of audiences.
So a couple things. First of all, we absolutely think we have defenses. and we do have some, but we don't have all the ones that we think we do. And the best evidence of this is the evidence that pure repetition gets us to like stuff we didn't originally like. And you can't, it seems to be almost ineradicable, at least given the commercial realities we face. But it is true, persuasion, what the marketing researchers call persuasion knowledge varies a lot among groups. There are different things you can do to change it, but I'm not sure that changes anything, especially in an environment where non-governmental groups are able to persuade you too. So the question that I have about these autonomy arguments is, what do they mean if they're defined to mean only autonomy from the government? That seems to be, to me, to be under-justified, especially when there are plausible arguments that private parties are not acting in ways that are autonomy enhancing.
I'm just curious. That's really good. I'm just curious to know more in sort of an age of mind sciences, to what extent decisional autonomy and that sort of dispositionist framework is a model that you think will continue to be sort of the model we look at.
So in terms of free speech jurisprudence, I absolutely believe that the courts are going to continue to act as if it exists. And probably that's the right thing to do. I mean, so all of these studies and all the evidence we have is probabilistic. All they can do is change the direction, right? They can't completely control it. Maybe there is something that is, but we don't know that yet. We don't know what it is yet. And given that, it makes sense to act as if there is at least some degree of freedom, it seems to me.
Well, since there's a pause, I want to talk a little bit about your distinction between, again, the abortion is murder. And I think you're right, they do try to frame it in terms of women's public health, but that is not, in fact, what actually motivates them. And I think if you actually look at why do they even assume women would even regret their abortion, the assumption is based on the idea that the woman has murdered a fetus, and therefore, when she recognizes that fact, will inevitably feel great sorrow for it. So I think however you characterize it, you're inevitably going to return to a contested moral proposition as the basis for the government's justification for it, which I think is a very different basis than the cigarette warnings.
Well, so is it contested, though, that we feel bad about murder? I mean, now so it is true that the question of what is murder is contested, but the government is actually, even on your framing, right, trying to get you to a point where something that you agree on, right, now you understand the facts differently and therefore are trying to reach your aims differently.
No, I think it depends on this idea that an abortion is akin to killing a whole separate, unique, living human being, which is, again, a contested moral proposition. But, well, I'm sorry, just leave it open to questions. No questions.
Anything else? Okay, so we can take our break and get us closer back to the original schedule. Thank you.